mandatory requirement of 17A.
If the foundation itself does not require,
Exactly.
why would a superstructure require?
Exactly. That's what I wanted to point out.
All right, next.
Therefore, that's first subject. Then, my lord, the second question would arise in the context of 17A. Should the recommendation be made or a decision to be taken by a public servant? It is to be relatable to.
No, in this case, relatable
Yes.
is quite debatable. We'll see.
Exactly,
Yes.
my lord. Relatable is debatable, my lord. I bow down. That is why an inquiry.
Yes.
My lord, if it was...
That is why an inquiry will see.
that's my submission, my lord.
Relatable is debatable.
Relatable is debate. That's right, my lord. I mean, at the stage of 17A, application of mind, there is no material which is available which can point in one or the other direction. It is a matter where suspicion, needle of suspicion.
No. Needle of suspicion pointing at a particular act of a particular person.
Quite right.
See, needle of suspicion also cannot be in thin air. So there should be something. And he has threadbare told what is there. We'll see whether it is relatable or not.
Quite right. Now, my lord, another important aspect that I want to bring to your lordship notice is relatable. No police officer shall conduct any inquiry or investigation into an offence alleged to have been committed by a public servant under this act. Now, what are the offences under the provisions of the PCA Act? My lord, kindly see Section 7. My lord, there's something that turns on Section 7, my lord, which I want to point.
Misconduct by a public servant.
No, my lord, there's something more. There's something more. I want your lordship to be kind enough to see Section 7.
Yes.
Any public servant who...
The offence relating to public servant.
Yes, quite. No, my lord.
No, see, 7 is offence relating to public servant being bribed.
No, my lord, kindly see C.
The 7C is 7C is the only thing that is something there.
Exactly, my lord. 7C, your lordship will kindly see, performs and no, my lord, more importantly is the explanation 1 and explanation 2 to Section 7. Performs or induces another public servant to perform improperly or dishonestly a public duty or to forbear performance of such duty in anticipation of, in consequence of accepting an undue advantage from any person. Now, this is explained by explanation number 1. For the purpose of this section, the obtaining, accepting, or the attempting to obtain an undue advantage shall itself constitute an offence, even if the performance of a public duty by a public servant is not or has not been improper. So, my lord, I ask myself the question, suppose, my lord, in a given case, what has been done is legal. But that legal act has been induced by a public servant.
No, then it does not become an offence.
But then, my lord, I ask myself, what was explanation 1? Then kindly see explanation 1.
No, don't, self-golagman.
No, my lord, kindly see, no, not in this case. Kindly see explanation 1. Otherwise, explanation 1 will have no meaning. Because for the purpose of this section, obtaining, accepting, or attempting to obtain an undue advantage shall itself constitute an offence, even if the performance of a public duty by a public servant is not or has not been improper. So let us assume, my lord, in a given case that it is not improper. I'm not in this case, my lord. I'm saying look at the width of the inquiry that is required to be made under Section 17A. It is for that purpose, my lord, that I'm pointing out this. In this case, my lord, I'm going to show to your lordships a few more facts.
2 more facts are there?
Yes, my lord. Yes. I'm going to show to your lordships a few
more than what he has told.
Yes, my lord. Yes, my lord. There is something more. And on the same facts that my learned friend has placed before your lordships, my lord, I want your lordships to look at it in a manner in which I would like to place it for your lordships.
Different angle.
Different angle, my lord. Therefore, my lord, that would throw some light, would move assistance to your lordships to see as to whether in this case there is something that requires to be investigated or the investigation to be scuttled without anything more. Because if the investigation is scuttled and the governor's order is set aside, there will be nothing more to be done in this case. Unless, my lord, it's a question of re-examination, rewriting, that's a different matter. But
the submissions are otherwise. If you leave that also, everything subsists. Is what he is.
I will, your lordships may look at that also. I'm not saying no. I'm not saying no, my lord. But there are different ways of looking at the same issue.
That's why yours is a different angle.
Exactly, my lord. That's why, my lord, when a lawyer, my lord, wanted an adjournment in court, on the ground, my lord, that he had forgotten his spectacles. That said, not necessary. Take my spectacles. I'm not going to grant you an adjournment. And the lawyer, my lord, used the judge's spectacles and still said, I want your honor adjournment. He said, why? I'm looking at a case from your point of view. I want to look at it from my point of view. So, my lord, the way, my lord, one learned counsel looks at it, the way your lordship looks at it, the way I look at it are all different. Therefore, my lord, I want to place it from the point of view of how I would look at it. Now, my lord, I have to give a meaning to explanation one. What is the purpose of saying even if the performance of a public duty by a public servant is not or has not been improper? Now, my lord, suppose, my lord, a legal thing is done in a given case, but it has been induced to be done by a public servant for the purpose of gaining an unfair advantage. Would that amount to an offense under the Act? My lord, explanation one seems to suggest that. Otherwise, my lord, these words shall itself constitute an offense even if the performance of a public duty is not or has not been improper. Therefore, my lord, it appears as if the philosophy of the Prevention of Corruption Act is do not use your public office to obtain an advantage.
Legal or illegal?
Exactly. All right. That seems to be the high pedestal of public morality, which, my lord, the Prevention of Corruption Act seeks to protect, my lord. Then, my lord, please look at explanation 2 in the same section, section 7. For the purposes of this section, the expressions obtains or accepts or attempts to obtain shall cover cases where a person being a public servant obtains or accepts or attempts to obtain any undue advantage for himself or for any other person by abusing his position as a public servant or by using his personal influence over another public servant or by any other corrupt or illegal means. So therefore, my lord, even if you have used your personal influence, not necessarily as the boss, not necessarily as the boss, even if you have used your personal influence, it comes within the mischief of section 7. My lord, in a given case, my lord, let's assume a public servant, a minister, my lord, is not in charge of the department. He has nothing, no role to play, but uses his personal influence. My lord, would it constitute an offense under section 7? Explanation 3, explanation 2 seems to suggest, yes, it is. The moment you hold a public office, it carries with it certain obligations and certain do's and don'ts, which are not attached to a non-public office. Therefore, my lord, even if you are not directly connected, but if you have used your personal influence over a particular matter in respect of which a decision has been taken and you are the beneficiary, that itself constitutes an offense under explanation 2 to section 7. Therefore, my lord, the contours of an offense in respect of which an inquiry is required to be held under section 17A are very wide. That's the point I'm trying to make for your lordship's consideration. Lord, it is not like a complaint which requires ingredients of the offense to be mentioned in the complaint, without which your lordships day in and day out interfere under 482 and quash it.
That's after registration of the crime.
My lord, it is after registration of the crime at the stage of investigation. Yes, but it could be, my lord, it never reached the court, excepting on FIR. Now, in a situation of that kind, even if there is, in the instant case, there are no allegations in the complaint, there's nothing. Still, if the sanctioning authority in the instant case being the Honorable Governor says, well, there is something that requires to be inquired into, not necessarily, my lord, as a list between A versus B, because the philosophy of 17A is different. The whole philosophy of the PCA Act is different. The philosophy, my lord, is to have a purity in public administration. That, my lord, is a paramount object of the Prevention of Corruption Act. If from that point of view, the sanctioning authority says, well, it is as important to be clean as it is to for the people to have confidence in a clean administration. Now, please look at it from that point of view, my lord. It's really not in the nature of a list between the petitioner and anybody else. It is in the interest of purity of public administration. If in that anxiety, if the sanctioning authority says, having regard to the high position that a person is holding, it is necessary that it should be inquired into, I ask myself, what is the scope of interference in a 226 judicial review proceedings? That, my lord, would be the approach I would suggest to your lordships to adopt in this case. It is really not a list between A versus B. There is an element of public interest. And if in that anxiety, the high functionary like the governor, and I will point out your lordship the judgment, my lord, which of course your lordships will be aware of it, that where a discretion is vested with a high functionary, the courts would be very reluctant to interfere with that order. My lord, your lordships are not going to look at, I would respectfully submit, with the order passed by the governor under 17A, in the same manner in which your lordship will look at an order passed by the Tahsildar.
It was submitted.
My lord?
That was argued.
Yes. So therefore, my lord, if it is so, and I'm going to show you some authorities on that. If that is the position, what is the extent to which this court can go into while examining the action of the governor acting under 17A, being a constitutional functionary? So therefore, my lord, what I would submit to your lordship is, please look at it from the point of view, not as an adversarial litigation. When your lordships are looking at the sanction under 17A, do not look at it as an adversarial litigation. Please look at it from the point of view of ensuring not only there is purity in public administration, but that public confidence in administration is not sullied. If it is damaged, it is restored. What is the best way of restoring, my lord, an eroded public confidence in administration?
Where is it eroded?
Well, let me develop it, but I will show to your lordships that. What is the best? Because it is the very fact that a commission of inquiry has been constituted under the Commissions of Inquiry Act itself indicates that there is an anxiety to get this matter inquired into because it is a matter of public importance. And that has been referred to by the Honorable Governor in the order. If it was a matter in respect of which no inquiry was required to be done, I ask myself, why was the Commission of Inquiry required? Whole object of the Commission of Inquiry Act is that you will have this inquired into in accordance with the special statute. In order, my lord, your lordship knows, my lord, that the report of the Commission.
So you are satisfied with the Commission of Inquiry?
No, my lord, no.
What is your suggestion?
I tell you lordships why. Commission of Inquiry Act, unfortunately, my lord, a report of a Commission of Inquiry has no teeth.
We'll give it.
No, but the statute doesn't, my lord. The statute doesn't, my lord. In fact, there was a recommendation made by the Supreme Court saying that something must be done, nothing has been done. And the Supreme Court, my lord, has recognized that all these commissions of inquiry report are put in cold storage.
We will not permit.
But that is an independent and a parallel remedy. That is not necessarily a bar to a sanction under 17A. Therefore, my lord, this submission I made is in answer to the aspect, my lord, of eroding public confidence in public administration. How is it eroded? The very fact that you constitute a commission of inquiry indicates that there is something to be inquired into. Is it something that does not require, is a matter of public importance, is what the Commission of Inquiry Act says.
There is something being inquired into.
Yes.
So
Yes.
Why all this exercise?
My lord?
Why all this exercise?
Of course, my lord, there are two parallel remedies. Of course, there are two parallel remedies.
Don't emphasize on what is being inquired into.
No, that is only to answer the question, my lord, as to where is the erosion of public confidence. If there was no fear of erosion of public confidence in public administration, then the question of constituting a commission of inquiry would not arise. It is from that point of view I am making the submission that The very fact that the government itself considers that there should be an inquiry into this matter and a matter of public importance itself indicates there is something that required to be inquired into. And all that is required under Section 17A is that there is something to be inquired into. And the entire allegations, my lord, are with respect to persons holding public office. Maybe, my lord, ultimately after inquiry, there will be a clean sheet. Maybe, maybe not be, I don't know. But why scuttle it at this stage? I mean, why not? Whatever is the truth. Maybe, my lord, there is truth in what is being alleged. Maybe there is truth in what is being said for the other side. We don't know at this point of time. Therefore, at this point of time, would your lordships want the cloud on the purity of public administration to remain? Is a question, my lord, I ask myself and pose it for your lordship's kind consideration. And I would say, my lord, that in matters of this kind, the courts must lean in favor of getting matters inquired. Not
ನೀವು ಅಷ್ಟೊಂದು ಪಾಸ್ ಕೊಟ್ಬಿಟ್ರೆ ಮಧ್ಯದಲ್ಲಿ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅದು
Courts which side lighter way, yes.
ಅದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ
The lighter ways.
I know.
Mind, yes.
No, I fully
Yes,
understand.
yes.
I fully understand, my lord. We have seen your lordships quite and we have gauged, my lord, to the best of our ability
Yes.
as to what the court means when the court is asking a question. We know that. The one thing that we are never able to gauge, my lord, and rightly so, is what is the final decision.
Oh, if you gauge that, then what?
Exactly, we can't do that. Adu ಸ್ವಲ್ಪ ಕಷ್ಟ.
Yes.
Adu best is not to do it, my lord.
Yeah.
So now, my lord, coming back to the point, my respectful submission to your lordship is please lean in favor of getting matters inquired into. That consideration when your lordships are looking at 19 would be different. And we are not concerned with that
Operates on a
today,
different
in a
way.
different. Now, my lord, having told your lordship that, my lord, I prepared a list of dates and factual aspects, and I want to take your lordship through a few factual aspects, which is relevant.
ರಂಗನಾಥ್ ರೆಡ್ಡಿ ನಿಮ್ದು ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಪೂರ್ತಿ ಇಲ್ಲ. ಎಸ್.
Please note, my lord, just a few things, that between 1996 and 1999, I mean, this is not there in this. I would trouble your lordship to kindly just note these periods.
1990?
6 to 1999, the petitioner was the deputy chief minister.
ಇದ್ರಲ್ಲಿ ಇದೆಯಾ ಅದು? ಇಲ್ಲ.
ಅದೊಂದು ಮಿಟ್ಟೋಗಿದೆ.
ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಬಿಟ್ಟು.
ಅದಕ್ಕೋಸ್ಕರ ಅದೇ ಯು ನೋ ರಿಟನ್ ದಟ್ ನೋ. ಐ ಆಮ್ ಸಾರಿ, ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್.
ಆಯ್ತು.
ಅದಕ್ಕೋಸ್ಕರ ಶುರು ಮಾಡಿದೆ, ಅದನ್ನ ಬಿಟ್ಟೋಗಿತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ಶುರು ಮಾಡಿದೆ. 1996 to 1999,
ಹಾ.
the petitioner was deputy chief minister.
ಡೆಪ್ಟಿ ಚೀಫ್ ಮಿನಿಸ್ಟರ್. ಹಾ.
2004 to 2000, I'm giving the dates which are relevant. 2004 to 2005, he was again a deputy chief minister.
1 year.
Yes.
ಆಮೇಲೆ
The first stint as chief minister was, my lord, between 2013 to 2018.
18.
And thereafter, my lord, the second stint is from May 2023.
One moment.
We are concerned with the property, my lord, bearing number 46, survey number 464,
ಕೆಸರೆ
measuring
ಗ್ರಾಮ.
3 acres and 16 gundas.
ಕೆಸರೆ ಗ್ರಾಮ ಕಸ್ಬಾ.
Exactly, my lord, exactly.
Yes.
My lord, this property was originally owned by one Ninga.
Granted.
Yes, my lord, it was granted and he was the owner. And he, my lord, had 3 sons, Mallaya, Mailaraya, and Devaraju. My lord, Mallaya and Devaraj relinquished their right in favor of Mailaraya. That your lordship gets it, my lord, at serial number 2 in the list of dates. Relinquishment deed by Mallaya and Devaraju over survey number 464 in favor of Mailaraya. Therefore, my lord, Devaraju had no right. It was property was owned by Mailaraya. It is noted that Devaraju name is shown in the revenue entries after Ninga and the name of Mailaraya is not depicted in the revenue entries. Then, my lord, I'm going to skip to a few things. Then your lordship may come to serial number 4. In 1991, Karnataka Urban Development Authority's incentive scheme for voluntary surrender of land rules 1991 came into force, while GO dated 29th of January 1994, retrospectively from the year 1991. According to the rules, a person is entitled to 4,800 square feet when the land is acquired between 3 acres to 4 acres. That is, my lord, they were entitled to, my lord, 2 sites. If the
Between
land is in excess of 3 acres.
3 acres.
My lordship may look at the rules, my lord. Your lordship may look at the statement.
All right. Yes.
Then, my lord, please look at serial number 6. My lord, I'm going to skip a few dates, my lord. May not be.
No,
It is given only for the
no, you
purpose of
can-
convenience. I'm
Narrate all the dates, no problem. But rules will go later.
very well, very well.
Yes.
Now, my lord, please look at serial number 6.
Hmm.
Government of Karnataka acquisition of land for development of Devanuru third phase by Muda, 3 acres 16 guntas of survey number 464 was mentioned in notification. Notification reflected late Sri Ninga's name. My lord, we have the notification is available for your lordship's consideration. Now, my lord, kindly see interestingly what happens is serial number 8.
Hmm.
Devaraju sought for denotification of land.
Devaraja was not the owner.
No,
Mailaraya was the owner.
exactly.
Hmm.
Mailaraya was the owner because of the 1968 relinquishment.
All
deed.
right. Yes.
Devaraju sought for denotification of the land. Endorsement of Muda recommending denotification of land, that is on 30th of August 1997. And now, my lord, final notification issued on 20th of August 1997 where this property is acquired. It is at serial number 40.
It was not yet denotified.
No, it was, in fact, this is the final notification.
No. But what is this denotification?
The recommendation. He made an application, there was a recommendation.
Recommendation on 38/1997.
Yes, correct.
All right. But just before that, a final notification is issued.
Yes,
All right.
exactly. And the notification and that relevant property, my lord, is at serial number 40 of the notification. There are number of properties. My lord. Then, my lord, 30th of March 1998, an award is passed. And the amount, my lord, has already been deposited in the revenue treasury. It has been deposited. So with that, my lord, acquisition is over now. There is nothing more to be done. Then comes the notification, my lord, at serial number 11. 18/5/1998, where there is a denotification of the survey number 464. This is where, my lord, the problem starts.
This was the only land denotified or anything else?
My lord, I'll check, my lord. I'll check then to answer your lordship's question. My lord, kindly, I tell you, lordship's, my lord.
No problem. Later you can tell us.
My lord, answer to your lordship's question is only this land.
Only this land?
Yes. It is at page 109.
Nobody had applied for denotification?
No, my lord, I don't know whether anybody had applied, but the fact of the matter is that the denotification of 18/5/1998 is pertaining only to this land.
All right.
And we are given the reference number, my lord, as a statement of objections.
Huh.
Then, my lord, interestingly, on 25